We go into the protection now, right? The SUP, P will be for protection, trademark protection. So if you want to register a trademark, what are the criteria? The key criteria are, first, your mark must be distinctive. Just now I have already explained what is meant by distinctiveness. Distinctive means it is not referring to the quality or the nature of your product or services. So that's the one criteria. If your mark is non-distinctive, then the registrar will raise an objection. The second is your mark in a particular country where you want to file your trademark must be a new mark, meaning it is not similar or confusingly similar to an earlier mark in that particular class. It's limited to the class of that you file the trademark. So let's say you want to register for shirt is class 25, then in that class 25, there's no earlier mark for your goods and for your trademark. So for that, you need to do a trademark search. Yeah, trademark search is something you need to do before you want to choose a mark. You need to do a trademark search to make sure that for that class, no one have registered before. So, and the mark, whether it's similar or not similar to an earlier mark, what do you look at, right? So the law has come up with a test, whether a mark is similar or not similar to the earlier mark. This is called a pianotis test. All trademark practitioners will use this pianotis test to compare two trademarks to see whether they are similar or not. So the pianotis test say you look at three things, right? You look at the sound, you look at the look, and you look at the overall concept. These are the three qualities that you look at. So if you compare your mark with the earlier mark, do they look the same? Do they sound the same? Do they have the same concept? So if you have 2 out of 3, then you will win. If you have 1 out of 3, you will lose, right? This is the kind of comparison that people will make. That's the pianotis test. So how similar is similar? Look at the pianotis test, right? So some example, this McCurry and McDonald, I think some of you might know. In this case, the court says that these 2 marks are not the same because it doesn't look the same, it doesn't sound the same, but the concept is the same. So it's 2 out of 3 in favor of not similar. Similarly, in this Polo Ralph Lauren versus US Polo Association, the Singapore court say these 2 marks are also not confusingly similar. Why? They don't sound the same, they don't look the same, but the concept is the same. 2 out of 3 in favor of not similar, right? So these are the things that we look at. I have no time to go into the merits of the cases, yeah, because of time constraint. And when you register a trademark, right, you have a composite mark. So what do you file? Do you file everything together or you file one by one? So it depends on whether you use them separately or not. If you use them separately, you should register them separately. Like Adidas, Impossible is Nothing. Sometimes those are used separately. So you need to register separately. And when you go to a foreign market, right? So if you go to China, for example, you are selling Adidas, but you have the Chinese name. So you need to register the English and the Chinese name together. You go to Japan, you go to Arab country, you may need to change your English name to the local language and register them so that you don't have a different character in the local market using the same sound, same name to confuse the market, right? So these are the things that you look at. And trademark, their classification, you need to understand that there are 45 classes. So when you register, you must choose the product and the services and the class that you want to register. But you have to also be aware, not all countries follow the same classification. In China, there are 488 subclasses. So you register in China, you have to look at subclasses, not just the class. So if you forget about that, you may lose certain market to your competitor, especially in a country like China. An example that I can share with you is Apple. Apple suffer a lot of losses in China in trademark. And there are a few examples. It is Apple registered the trademark in class 9, but in China they have subclass. They don't follow the main class, so they register 0901. And there's a company called Hanwang. They register Apple iPhone in class 0907. Apple, when they register 0901, they thought, oh, all class 9 is registered already. But they didn't know that China followed the subclass system. So Hanwang take advantage and they register 0909, 0907. If you look at Hanwang and also Apple 901, they register for Jisuanji. Jisuanji is for computer. Whereas Hanwang, when they register 0907 is for 电话机 is for phone. So Hanwang register the right class. Apple register the wrong class, right? Apple started very early in year 2002, but they registered class 9 thinking that, oh, American law 9 cover all and under 9, but they have a subclass system. So it ended up Apple having to buy that iPhone trademark from Hanwang for how much we don't know, but surely will be quite a lot of money that they have to buy, right? And roughly about trademark process, right? So trademark process is complicated. I don't have time to go in, but what I can say here is you do a trademark, then the trademark will be examined. If examination, your mark is not distinctive, not new, the registrar will raise an objection. You have to overcome it. If if it can overcome that, it will go to publication, it will be gazetted, and after gazetted, the trademark will be approved, and you will need to renew for every 10 years. So this is, you have use a notice. If it's a trademark under application, you put TM or SM. If it's registered, you put an R, and it lasts for 10 years, and you can renew for 10 years, right? Many 10 years to come. So after you register the mark, it doesn't mean it will be yours forever. If you don't use it for more than 2 years, or someone can cancel it. Yeah, so you have to jaga your mark to make sure it's protected. Okay.